Good morning. Robert Curtis, representing the appellant Limoliner.
SJC-12033, Limoliner, Inc. v. Dattco, Inc.
Good morning, Robert Curtis, representing the appellant Limoliner.
Mr. Curtis, 1 second, give us a chance.
Oh, sure.
Give us a chance. And don't expect applause after you're finished, I'm sorry.
I won't.
Okay, now you may begin.
Good morning, and may it please the court. The certified question before the court today asks whether Section 505 of the Attorney General's Motor Vehicle Regulations is meant to apply in the business-to-business context. I contend that the answer to that question is yes, because the context and the language of the regulation clearly suggests that that was the Attorney General's intent in drafting the regulation. In 1994, this court conducted a similar analysis with a different regulation. That was the Knapp case. And when you apply the analytical framework used in the Knapp case to this regulation, it shows that the intent of the Attorney General was to apply in both Section 9 and Section 11 cases under Chapter 93A.
And what is the practical consequence if you do not prevail here?
The practical consequence, if we do not prevail, would be that if a business, particularly a small business, for example, were to have an issue with a motor vehicle and get it repaired, they may have no understanding of motor vehicle repair whatsoever, yet they are not going to be able to use the benefits of Chapter 93A through this regulation to the extent that there's an unfair or deceptive practice.
Is it your view that if there were a sole proprietor who had his car be a business expense and was owned by the business, that this regulation would not protect that sole proprietor using a car in the course of business to be protected from the unscrupulous car repair shop?
Correct. If the court rules against us today, that would be the case. And that would be probably on the more extreme end, because the sole practitioner or the person working as an unincorporated business is closer to a consumer than to a large corporation. However, I think there's a gray area there, but the point is that the Attorney General, in this context, with regard to motor vehicle repairs and service, intended for it to apply not just to the individual, not just to the small business owner, but in the context of every motor vehicle. And the reason for that, there's a couple of reasons. First of all, if we look at the time context of the promulgation of this regulation, it's different than the regulation at issue in the Knapp case. In Knapp, that regulation was promulgated before there was a Section 11. So the Attorney General at that time couldn't have intended for it to apply in a Section 11 context because there was no Section 11 at that point. Here, it's different. Here, the Attorney General promulgated this regulation after Section 11 came into play. Now, that's not to say that every Attorney General's regulation after Section 11 automatically applies in Section 11.
You think, given that clearly the first one, the one in Knapp, didn't, that if the Attorney General, once Section 11 passes, you don't think that the Attorney General might say something in the beginning of the regulation, this applies to 11 too?
I think ideally that would have been great had the Attorney General done that, but the Attorney General didn't do that. The Attorney General also, though, did not say this only applies in Section 9 cases. What the Attorney General did do, though, is define the protected class as a customer, and a customer is anybody include.
Were also used in the regulation that was at issue in Knapp?
It was, but there was no definition of customer in Knapp. And it was also used, as the Knapp court found, interchangeably with the term consumer. And I believe the Knapp court applied the general definition of consumer, which if you look it up in Black's Law Dictionary, which I cited, a consumer is a natural person who is using it for, household purposes or something of that nature. Here, the Attorney General defined the term customer as a person. Then it defined the term person to include corporations. Now, had the Attorney General not wanted to include corporations or
definition that's in the earlier regulation?
It is, but in the earlier regulation, the term person did not directly bear on the definition of the protected class. There's nowhere in the earlier, in Section 308, or even in the entire general regulation, Section 3.00, you know, in general, where it says that the protected class is a person. So yes, it has the same definition of person, but it doesn't bear on that particular definition of who's protected. Here it does, and that's what the difference is. Now, there are other regulations that the Attorney General has since promulgated where the definition of the protected class is limited to a natural person. Had the Attorney General intended to do that here with this regulation, he would have used that terminology. He would have defined a customer as a natural person who is using the automobile for, you know, personal use or something of that nature. In fact, in Section 504, which is part of the motor vehicle regulation, the very top of it says that that particular subsection only applies to vehicles used for personal use. So the Attorney General knew that he could and should limit it to consumer use if necessary. He did that with Section 504. He didn't do that with Section 505. Instead, he used the broad definitions, which include corporations.
What year was 505 passed?
My understanding is 1976.
Or 7, one of them.
Passed in
was
76, effective in 77, I believe, correct.
So the AG, when he or she promulgated it, in 1976, would not have had the benefit of NAP, because that was 1994 opinion.
True, he would not have had the benefit of NAP, but he did know that he had the power to regulate Section 11 cases, because that's part of 93A, and Section 11 was enacted in 1972. So by that point, he knew he had that power. And again, Section 504, he limited the scope of that section to only consumer transactions.
But hasn't there been a common understanding over the last 40 years or so that the Attorney General's regulation in this entire area applies to consumer transactions?
I don't know that that's 100% accurate, or to the extent that that statement is accurate, I'm not sure if the concept is accurate.
But if the statement has at least some public impact, wouldn't it have been incumbent upon the Attorney General to make it clear that these regulations have to do with business transactions as well as consumer transactions?
I think it may, but the NAP holding, which all of the other authorities out there really derive from NAP, was limited to that one regulation. And the general regulation is entirely separate from the motor vehicle regulation. So could or should the Attorney General maybe have spoken up after NAP and said, yes, the general regulation is limited to consumers, but these others are not? Maybe. The Attorney General didn't do that. The Attorney General didn't even file an amicus brief here, which I'm not sure why that's the case, but the opportunity was there to sort of explain that, and she chose not to.
If you look at this treatise that is cited by Chief Judge Saris in her Baker versus Goldman Sachs, she cites the McHugh treatise on the Attorney General regulations under 93A. I mean, this is not ancient history. This is prepared for continuing legal education in Massachusetts, 2010. The reasoning of the Knapp case suggests that none of the Attorney General's regulation will be applied to Section 11 cases until and unless the Attorney General promulgates regulation dealing specifically with business-to-business disputes. So that has indeed been the common understanding. You were asking us to completely change the game.
Well, correct to an extent. First of all, as I've argued in the reply brief, I'm not so sure that that particular resource is entirely accurate. When you look at it, there's first of all, it seems to be some confusion between the general regulation, which is Chapter 3.0, and the Attorney General's regulations as an entire body. So I'm not so sure that that was clearly...
Well, these are regulations under Chapter 93A, which is what we're talking about.
Correct, but also all of the other authorities, and I believe that the more recent version of that material cites to the federal case, which is also under the general regulation. It was Section 3.16. So again, those are all general regulation cases. I think maybe that authority that was cited, the MCLE materials, is correct with regard to regulation, the general regulations. Those may all be consumer only. We're talking about the motor vehicle regulation, which is different. And there's no authority anywhere, Not even in that material, because it doesn't specifically address the motor vehicle regulation. There's no authority anywhere that says the motor vehicle regulation is only limited to consumer matters.
Is there any regulation as part of 940 CMR, those are all the 93A regulations,
Correct.
right?
Correct.
Is there any regulation in there that you've seen applied to businesses as opposed to consumers? In any case?
No. For example, like you mean trial court cases or whatever? No, I haven't seen that one way or another. I don't know that that's not true or not. I know that even before NAP, some of the the Chapter 3 general regulation cases were held to apply in business-to-business context. But so it may or may not be out there, that authority under a different regulation. Ultimately, though, as the NAP court did with the general regulation, I think we have to perform that analysis to determine the Attorney General's intent. I think that analysis even trumps what was in a secondary authority, even if that was the general understanding to this point. This court has the power to say, regardless of what the general understanding was up to this point, and I'm not conceding that it was entirely, what we're talking about here, but even still, if you analyze Section 505 and you look at it and you perform the NAP analysis, you see that it was, in fact, intended to apply both in the consumer context and the business-to-business context. And that's really what needs to be done here, is that NAP analysis. That's the importance of the NAP case. NAP only spoke to 308, actually 308 subsection 2. It was limited to that subsection. In that case, I think the analysis was accurate with regard to that regulation, but it's not a blanket rule that applies to every regulation.
Now, you say that the principle of NAP is that it's the intent of the AG which governs. It's to be treated essentially as a legislature, and we attempt to discern his intent.
Absolutely.
But I assume we have no equivalent of legislative history here to do that, do we?
No, with regulations, it's tough to find anything of that nature. But that being said, a legislative or regulatory history, it's helpful, but you still have the language of the regulation itself.
Do we know historically what prompted the promulgation of 5.05?
I don't know that. However, it seems to me, and I don't mean to speculate here, but with regard to motor vehicle repairs and services, it's a very specialized area. And just because you're in business, I could own a huge plumbing corporation and know everything there is about plumbing, but not know the first thing about how to repair my trucks. So it's a different set of circumstances. It's not really necessarily about bargaining power, where it is maybe under a case that involves, sales or warranties or something like that. There you're talking about bargaining power between two businesses, and they have the business savvy to argue what's an appropriate warranty. Here we're talking about something very, very specific. And it seems to me that that's what the Attorney General was trying to address here, and in doing so, felt that not only do consumers deserve this protection, but so do the business owners who know nothing about automotive repair and who are entitled to the same protections.
Well, you certainly can't claim that Limoliner knows nothing about auto repair.
No, correct.
Do auto repair.
They don't, well, they repair some of their own vehicles, but as the record showed, and this record may not completely reflect it as much as the trial or the appeal in the federal circuit, this matter was beyond their specialization, which is why they sent it out.
But this inverter thing?
Yeah, these inverters. And in any event, however, though, here today, we're here on a sort of limited scope. The First Circuit retained jurisdiction over this case, and they may very well address your concern when they get the case back. But the question is, in a general sense, does this regulation apply in the business-to-business context? And, again, for the reasons that are, I think the language and the context of this regulation, it shows that it was, in fact, intended to apply.
Thank you, Counsel.
I think I've covered everything I need to cover. If there are any other questions?
All right, thank you.
No? Okay, great, thank you.
Mr. Williams, good morning.
Your Honors, if I may, Christopher Williams for the Dattco Incorporated. A couple things I want to point out that Limoliner kind of rests their case upon, and that is the timing of this regulation with respect to Section 9, Section 11, NAP. And I'm not sure that that really has anything to do with proving or otherwise showing the Attorney General's intent in enacting this legislation. Because don't forget, the Attorney General had the right to enact the legislation to apply to only consumer transactions if it wanted to. And again, NAP suggested that if it didn't want that to happen and it wanted it to apply to even business-to-business transactions, it would specifically say so.
Yeah, but in NAP, how could the AG had no authority
I agree, Your Honor. That's-
at the time. So certainly, if the AG were to issue regulations that would govern business without, they would have to, and then the authorization subsequently to do so came, of course, they would have to say, we're going to now amend our regulations to make clear that we are now going to do what we have since become authorized to do, which is to apply it to businesses. So
That's exactly my point, though, Your Honor, and that is that this regulation comes out in 1977. And beginning in the 1980s, the early 1980s, at least the appeals court started to determine what the standard of liability was under Section 11 and came up with a vastly different liability under Section 11 than Section 9. If you recall the cases that talk about the someone inured to the rough and tumble world of business that would shock the conscience of someone.
Elizabeth's Cass language.
Exactly. And what we're talking about is there's a different standard right there.
Well, supposing you had two business people, one incorporated, one unincorporated, and they both cleaned people's houses, and they both had vans, and, you know, with lettering on the van. Is the result the same when they both go to an automobile repair place?
I'm not so certain about that, Your Honor, because number one, it's very possible that they own the vehicles as individuals. The other situation
Well, in one
may
case,
be-
they own the van, or they own the vehicle as an individual, a DBA, and the other case, they own it, the corporation owns it. Is there a different result in those two cases?
I think there may be, only because they've chosen the corporate form for a reason. No matter how small or how large you are, you choose a corporate form for a reason, whether
But
it's
they're
a tax
both
reason.
but they're both businesses.
Understood, but in one situation, it's an individual owning the vehicle that brings it to the repair shop. In the other
Counsel, may
situation,
I ask, I'm sorry to cut you off.
no, that's fine, Your Honor.
I'm looking at the definition of motor vehicle, and it includes a range of vehicles that would never be associated with a consumer. So how do you explain that?
I would ask you to point out one for me, Your Honor, because that's not necessarily true, because the definition employed in this statute is in Chapter 90, Section 1, which is basically anything that's pushed by a motor or towed.
That's my point. So it includes a bus.
It
So
very could be.
what is
I
the
could own a
consumer's
bus.
relationship to a bus? Why would you have a bus unless you were in business of some
Not true,
sort?
Your Honor. People take buses and rehab them to make campers out of them. People do all kinds of things with buses,
Would
Your
it
Honor.
include tractor trailers?
I'm sorry?
Definition include tractor trailers, semis?
I would assume it would, because it's
That's
a
not,
vehicle that's
not a
propelled.
pleasure vehicle in the ordinary course.
I'm sorry?
I said that's not a pleasure vehicle in the ordinary
It's
course.
definitely not a pleasure vehicle. You're right, Your Honor, but it doesn't mean it can't be used or owned by an individual, and in a lot of cases, they are.
But that wouldn't make any sense in the scheme of things here, would it? Why would the definition be expanded to include all of those categories that you don't traditionally associate with consumers unless there was an intent to have these regulations apply to businesses? I mean, that's really telling.
I don't think it is, Your Honor. I think that the Attorney General's office used a definition that existed in a
Well,
statute.
they could have just said cars.
They could have
or-
said cars.
Or vehicles owned by a consumer. They could have said
but
that.
they didn't. And
Right.
the problem is, but they also didn't say that this applies to businesses. Getting back to my original point, though, and that is that following the court's coming up with that language about the liability under Section 11, the AG's office in the 25-plus, actually the 35-plus years since those decisions started coming down, has not made any effort to change the language of this regulation. Following Knapp in 1994, when Knapp clearly indicated that, hey, it looks like unless and until you say this is going to be applicable to Section 11 claims, it's not. They still, in the 22 years since then, they've made no effort to add even 2 words, 3 words to that regulation to make it applicable. You're right, the common understanding since Knapp has been that these don't apply, that these do not apply, and that's why you can't find a single case anyplace. Limoliner hasn't suggested any, I haven't suggested any, that deals with this issue where someone has said, well, wait a minute, this applies to business claims. Is this really the first time this has arisen? I mean, that's the whole point with the dates, and that's why I see the date not being that strong a position for Limoliner, because I think it's just as likely the AG's office said, we're going to do just, Section 9 type claims rather than Section 11.
So if you're right, Jim brings his car into an auto repair shop. Auto repair shop has to know whether or not he's obligated under 505 to provide an estimate and get authorization for all jobs, or whether they can do whatever they darn well please. So they have to explore with Jim who the true owner of the car is. Are you bringing it in for a business? Is this your personal car? Is there a DBA? Is there a single-person corporation? You have to have that inquiry each time the car is brought in?
I'm not sure that that would be the realistic outcome of this, Your Honor, because I think the repair shops are in the position of doing exactly that now, whether it's a business, whether it's a small business, whether it's an individual. Here, we're talking about a very specialized situation between Limoliner and Dattco. We're dealing with 2 bus companies that clearly are on equal footing here, and it's very different than in
Well, I
that case, because
understand
don't
for
think
this, but you're not asking, the federal court will resolve this case.
Understood.
We're just being asked to determine whether or not it applies only to consumers and not to businesses, but the rule that will be established in this case will determine whether an auto shop is governed by this. And the auto shop then may need to ascertain the true ownership of it in order to do that, and if turns out they're not a consumer, they don't need to give them an estimate and get authorization for the work. They can just do the work and say, here's the bill.
Well, I think that the consumer, even a business, would still have rights against them, regular tort or contract type rights, but just not necessarily a 93A type right. Because that's what we're talking about here, Your Honor. I mean, if they do a shoddy repair, I would still have a contractual right to go after them, no matter who I am, for that shoddy repair. So it's not a question of, it's a question of whether there are going to be penalties
Well,
under
it's a question of whether you're
93A.
going to have attorney's fees or
Right,
treble damages,
exactly.
which is going to determine whether or not it makes any sense to actually bring that claim, because without attorney's fees, there's not going to be enough money involved to justify doing it, except as the small claims.
Such is the situation here, Your Honor. So, I mean, and I understand where you're going with this, because it is, I think it does draw a line, and it does say that if it's a business, it's not going to be covered. But again, that's the way things have run for the last 22-plus years.
I take it your point would be the Attorney General, if she wanted to, could change that.
Absolutely. I mean,
Counsel,
she's
yeah.
had more than one opportunity over the years. I'm sorry, Your Honor.
No, it's all right. Your brother counsel has pointed out that, of course, Chapter 3 of 940 CMR is specifically entitled Customer Protection, and the case such as Knapp and the one that the Goldman Sachs case decided by Judge Saris all deal with regulations promulgated under that chapter, whereas Section 5, which is what we're dealing with here, is simply entitled Motor Vehicle Regulations. So it doesn't say anything about consumer in its title and is a separate chapter. Does that make a difference?
I don't think it does, Your Honor, because not only does it not say anything about consumer, it doesn't say anything about businesses either. It doesn't say anything about Section 11. I will point out, though, that Knapp talked about the types of transactions that are uniquely consumer, uniquely rooted in Section 9. And again, we have almost identical type instances in this regulation that are talked about in the regulation at issue in NAP. In fact, I pointed out in my brief, the written waiver that's in this section, that's in this regulation, is uniquely consumer-oriented. It says, I understand that I have the right to know before authorizing any repairs what the repairs to my car will be and what their cost will be.
Well, that could certainly apply to a business. I mean, there is a human being who has brought that car in,
Absolutely,
or
but
that bus, or whatever it is. I mean,
they could have
so-
said my motor vehicle, they could have said the motor vehicle I brought in, something to that effect. That's what I'm saying is that this almost tracks the regulation at issue in NAP, in what they talk about in terms of what is uniquely consumer and rooted in Section 9. I think there's plenty of instances, including this waiver. And the NAP court pointed out language in that other regulation that was similar in that it said, you know, to show that it was a commercial, a consumer-type regulation. And finally, with respect to the definitions, again, I don't see those as necessarily being the black and white of what this is about. Because again, person is defined the same way. In fact, the only difference is, I believe, in one of them, person includes a trust. But person is defined the same way in both regulations. Again, the motor vehicle, defining a motor vehicle, that's a general definition that exists already in the statutes. Yes, they could have written it differently, but they didn't. But I think, again, the most important thing is that in the 22 years since NAP, been no effort to change this whatsoever.
Sorry, change this or change the regulation in NAP?
Change the well, either one. There's been no effort to change either one.
So to you, 94 is the significant date, not 70, whatever.
Actually, I think
77.
probably 1981 is, with the appeals court's decision in the case, talking about the
Well-
different standard. But you're right, I agree. That would, I mean, if you're going to read into the fact that the Attorney General knew that Section 11 was passed and existed, and they had the power to legislate under that, then they certainly had to know about the appeals court's decisions in the early 1980s. They most definitely had to know about NAP, because it involved specifically one of their own regulations, and they absolutely had to know about today. And yet they offered nothing in support of Limoliner's position today.
So if you're right, there's no protection for small businesses, small farms?
It would depend on the circumstances, Your Honor. Again, I look at it
Why-
as...
Why would it depend? I mean,
Well-
a small business and a small farm would own their own vehicles.
Right, but the small business, if it's in a corporate form, has chosen that corporate form for a reason, to be in a business sense. If you're a sole proprietorship, like me, for instance, if I'm using my vehicle to go, I mean, why am I not bringing the vehicle to my repair shop as an individual? I'm not incorporated. I'm a DBA, and I use my vehicle mostly for my business, but I'm an individual owning that vehicle.
And would it matter whether or not you're expensing that vehicle as a business expense in
I don't
terms
think
of
it
whether
would,
you
Your Honor.
qualify for this protection?
So it's the corporate formality alone, that's where the line is, the corporate
No,
formality?
I don't necessarily think it is. We haven't really researched the issue as to how far it would go
Limited
out.
liability corporation or a limited partnership or something like that, is that a business too?
I think you get closer to it that way,
So
because
there are no sort of set lines here? Somebody could argue.
I don't know a set line at this point, Your Honor. You're right.
But that's a larger question. That's a larger question about what triggers Section 11 versus Section 9. That's
Correct.
not about this regulation.
Right. I agree.
Okay, thank you.
Thank you.